That doesn't do anybody any good that's lost their home, lost everything they've had, and simply can't live under the conditions that they're living under. And we see so many people like that. As I said earlier, people that are professionals, working in places that they make very good income, and indeed can have an excellent lifestyle. Why would somebody with that kind of lifestyle potential want to stay home and get no income at all and not really serve the thing that they work so hard to get in their profession? It doesn't make sense. So chronic pain is real, and it is real for people in the community that live with it every day. The other thing is, we have to see that the Supreme Court has made the decision. On October the 3rd, the decision came down, indicating by April the 3rd of 2004, we have to have a system in place that's forced this bill to come about. It's unfortunate it had to come that way, but at least it's there. And chronic pain must be treated like any other injury in industry or in business today. We have to see the opportunity for people that are really injured or really hurt, that they can live a lifestyle that's reasonable. It doesn't mean that what people want to travel all the time or do anything else, because most of the people in chronic pain simply can't do that. They want to just know that they're being fairly compensated for the pain and suffering that they've had in the past. The government says it allows workers' compensation appeals to handle chronic pain cases. Well, workers' compensation tribunal they're an appropriate body to deal with these issues. But are they going to have enough resources to deal with that? You look at the potential estimated $119 million a year that this is going to create. With this new ruling by the federal court, and I'd like to know from the minister, when he does do his wrap-up comments again on this part of the bill, how he proposes to pay for that. It can only be in one or two ways. You can either put the assessment up for industry, broaden the area of assessment, which it appears is going to be in the bill here in Section 2, subsection 3, 1 and 2, where lots of small companies, maybe 1 or 2 employees, 3 employees, is now going to be hit with workers' compensation. Now that may be good for the homeowner that gets someone to repair the roof that doesn't have compensation, that could be sued for someone that gets injured on their property, or other things. It may help the bigger businesses eliminate the small business. All kinds of things can happen. But it's going to affect a tremendous number of small businesses in this province. Businesses that are usually mom and dad operations, maybe have one employee beside themselves, and are trying to make a living and eke out a living over time to do the things that they want to do. Usually have to work 60, 100 hours a week just to make the ends meet. You add the burden of workers' compensation on top of this, and you've got a situation that's marked for disaster. Then if you go down further in that section of the bill, and the government and council may, by regulation, exclude any industry, including any commercial or professional activity, from the application of this act. Does that mean that government can come along later? The government and council, cabinet can say, okay, Michelin Tire, for instance, we don't want them to have to pay workers' compensation. We'll exclude them. Maybe they'll come along and say, Fred's Pizza Shop down the road, because he's a friend of government, maybe he shouldn't pay compensation. Maybe someone else in a broader industry may not want to pay this compensation, so they just exempt them. What process will government and council go through to make sure that that's fair and equitable for all Nova Scotians? And not just exempt somebody because they want to exempt them, and all the other industries in the province end up paying more money. That could easily happen. I think those clauses have to be tightened up, and tightened up substantially in order that there's some accountability and rules and regulations of how these can work. Then the board shall calculate the amount of compensation. When you go down to 4.3, shall calculate the amount of compensation payable for chronic pain in accordance with the regulations. That's interesting. And who makes the regulations but the governor and council? So they can rework the regulations to make sure that the compensatable payments for chronic pain aren't acceptable. Interesting scenario, but possible. I would hope that governor and council would never do that, but you never know what may do when they're faced with a financial crisis. I want to go back again to another item. Actually, I'm going to skip forward before I do that. Another Section 8, and I'm not going clause by clause on this thing, but just some issues here I want to bring forward. The annual general meeting, at the annual general meeting, which is under Section 8, subsection 2, number 6, at the annual general meeting, report referred to in subsection 2 shall be discussed along with any matters raised in regulation to report by those present at the meeting. Now, I'd like some clarification on that. I'd like to know if that is that's a public that comes, the people that come, or sometimes you have these meetings with organizations and boards. They decide it's only the board's going to speak. Public? Thank you very much. That answers that question. And the other thing is I'm going to ask about the board should hold annual general meetings each year to open to the public, and I think that's a very positive move. It doesn't indicate in here, though, when that public meeting is going to be. Annual general meeting, can they adjust it throughout the year, or shall be in a certain part of the year? I think that probably should have some more clarification as we move forward so people can plan for the meeting and know when it's going to be. And I would hope that we can address those issues as we move forward. I think those are important improvements in the Act, and things that need to be done. And the more accountable the board can be to the public and to the general public, I think the better off we will all be. And I think those are positive steps forward. And there's I'm glad to see that some of these things are going to change. You look at item number 12, where it's talking about the Chief Worker Advisor must report to the Deputy Minister of Environmental Labour with respect to carrying out the duties of the Chief Worker Advisor. I think that's a positive step forward. As long, again, it's a report, and I think that we should have some clarification what that report should include. It should be the things, particular things that should be indicated there so that the Deputy Minister and the Minister of the time will have more detail, know exactly what to expect to ensure that the information come forward is what the department needs to really judge whether the information is accurate and where it needs to be. I'm going to go back again where the occupational health and safety is going to be transferred from the Department of Labor. Again, I've got great concerns about that. Not the fact that it's going to the Workers' Compensation Board, but where the funding is going to come from. That's something that probably over the years have been heavily underfunded, and as a result of that, we've had more injuries probably in the province than we should have. And there's things that maybe we need to find out. I know at one time, and there's been major progress made on this, which I give all the people involved with great credit with, is the woods workers had the highest compensation in the province, and I understand that that's been addressed some and improved some, so it's a lot better. Although you still can't find people to work, or because the cost is too high and the pay is not adequate as a result of some of the high costs of doing that. But has there been any detailed research done and seeing exactly what kind of injuries were done, and then addressed by the occupational health and safety people to address those exact injuries? Were there more cuts on the hand? Were there more cuts on the leg? Were people trapped under trees? What exactly were the causes of all the injuries? I'm sure those statistics are there, and if not, that's something we should be collecting to help reduce the injuries as time goes on. And there may be some new safety equipment that could be developed to prevent some of these injuries. And I think that could be said with all industry. There's certain type of injuries that are related with every type of industry, and if we're going to eliminate those and help eliminate those will go a long way towards cutting the cost, number one, and number two, making sure that people don't get hurt, which is very, very important. If you've got a worker, I can tell you as an employer, if you got one of your best employees, and typically if you're a good employer, you have all good employees, you get one of your best employees injured, he'll get injured the day before your big contract has to be delivered, and he's going to be off for 3 weeks. So it causes big problems. So the cost to employers is indeed very, very high. And then at the end of it, if the employee is injured and the cost of the workers' compensation goes up, the employer pays more, and then it costs more to your customers, and everybody loses. Just no win. It's a no-win situation. So we have to make sure that those things really have to seriously be looked at, and there needs to be a structure in that to do it. I'd like to see more detail in the bill. After working on workers' compensation cases with constituents for many years, with very little or no results from the Workers' Compensation Board, get inadequate information. I think it's time we laid out more in the Act to make sure that people that know that they're being treated fairly, to being treated to the Act, and that some counselor can't decide he's going to interpret the regulations or rules or create new ones to the best advantage of the board. It really has to be set that way. It's good to see that you're going to change the Act here, that anyone that's working on behalf of an individual can get the information, all the information with the person's permission, of course, and that will assist workers with advisors greatly. It's time that happened, and I'm glad to see that that's in the Act. All in all, there's some very good things in this Act, but there's many more things that have to be added and changed and corrected here to make sure that it's fair for the workers, fair for the employers, and also fair for the taxpayers of this province so we're not hit with another $500 million in unfunded liabilities we've seen a few years ago. It's interesting to see the Supreme Court. I wouldn't want to be on the Workers' Board, the Workers' Compensation Board, making a review tribunal when you have to take so many things into consideration and make sure that protection of the worker is foremost. And because I believe there's very few people that try to rip the system off. There's probably some, as in everything, but there's very few. And it's important to see the people that do have an injury are properly compensated and hopefully get back to work as quickly as possible. That again goes with a lot of education, a lot of hard work on behalf of the employers and the government and the employees themselves. It's again disappointing, has been said here many times by many people, that the bill does not go significantly further towards a full implementation of the Dorsey report. And that's been talked about here in detail, and I know some of those recommendations have been moved on, but it's something that has to move a lot quicker. At the rate they're going now, it appears it'll be about 10 years before the Dorsey report would be fully implemented, and then by that time it'll be definitely out of date, as the workplace is changing, and as the workplace is more and more technology today, and less of the typical type of injuries we've seen. It's going to be interesting in the next few years to see what's going to happen with industry. You started years ago when it was all manual labor. People would have a broken leg or a broken back or whatever the case may be, and they'd be offered compensation. Now you're seeing things such as chronic pain, there's fatigue, there's things that injury of your eyesight due to watching a computer screen every day, the cancers that are caused that the firemen, thank goodness, had finally get compensation to cover, which I congratulate the government for doing that. It's so many things that are new and that are coming. And I would hope that the Act has some provision in, could put some provision in the Act to look at these things in a more timely manner. It's important that these changes are there, and we have to see that the people are protected as time goes forward. And compensation is a no-win situation. If you're an employer, it costs you a lot of money, puts your operating cost up, and if you're competing in an international market, it makes it very difficult. If you're an employee and you get injured, you have to make sure that the compensation is there and to a level that you don't lose your home and everything that you've worked all your life to acquire. And also puts a lot of stress on your family to the fact that maybe the key breadwinner in the home can no longer get the income that they need to do the things they have to do. Maybe they have small children at home, and it puts a tremendous burden on marriages and the whole system in the community. And it's an awful thing, you know, if someone's off, and I say I deal with a lot of people that have chronic pain and illnesses, and even the problems now with the environmental illnesses. The things that are coming now that people didn't even know about years ago are become more and more relevant, I should say, and it's going to be very difficult. We have to really look forward and see if we can prevent some of these things from becoming a problem like chronic pain did in the past. And we talk about chronic pain, and you look at the potential unfunded liability of $119 million. And the other day, we were talking about this, and really nobody is sure just how big that unfunded liability is going to be. And nobody could know, of course, until all the people make application that could be considered under this act. It's difficult. It's difficult for me as an MLA. It's difficult for me as a former business person. And it's difficult for a person that works with individuals that suffer from chronic pain. As I alluded to earlier, when you see one of the doctors from the Workers' Compensation Board indicating that the people that he sees, most of them are layabouts and don't want to work and everything under the sun, a presentation I frankly couldn't believe, but it was there, it was real. And he even had it up on a slide with the computer. And I think that's something maybe the minister should probably have a look at, and we can get him a copy of that if he's interested sometime. And I think it was prejudiced before, possibly prejudiced for anyone that was going there for a claim, and that really disturbs me, and as it should anyone that's involved in this sort of process. I'm worried too with the Workers' Compensation Board. It's been a common practice in the past to draft regulations later. And I know regulations make it a lot easier to make changes quickly and to modify things and to do things that can solve a problem quickly. But with the history of the Workers' Compensation Board, that makes me really nervous. If you're a worker and you see all the things that can happen, if you're an employer and see the things that can happen with the Workers' Compensation Board, it's scary. It's really scary. I mean, we're looking at, you know, you look at an employer, say in the past, you had to make this guesstimate of what your payroll was going to be for a whole year, and maybe you're going to have a good year this year, maybe you're not. Then you had to write a check. You had to write a check for the full amount or pay a penalty. And then if your guesstimate was wrong, as I said earlier, you had to pay, I think it was a 20% penalty plus interest on if you underestimated. So that discouraged people from underestimating. But if you overestimated and you had that money tied up that whole time, then you didn't get any interest back from the Workers' Compensation Board. They didn't pay you a penalty of 20% back or anything like that. So it really crippled Nova Scotia business. It really, really did. So that change was good. That was a positive change. But I like to see these positive changes right in the Act, not in regulation, because there's too many opportunities for someone to come along, maybe not this year or next year, maybe 5 years down the road and say, here's a regulation in the Act. We can make another $100 million over 10 years out of this. Let's change the regulation. Bang, it's done. All of a sudden, industry's got a bill they can't cope with. The board is trying to cut back maybe other places, and the workers have a problem as well. So everybody loses. It's better to have it in the Act. The Act has got to be very, very clear. There can't be anything in there that can be read one or more ways. It's got to be very straightforward. I know that's difficult to do, and I know the people that work on the Acts here try very hard to do that. But it is very, very difficult. I asked earlier about the wording in 8.6, report to all those present, talking about an annual general meeting of the Workers' Compensation Board itself, and it doesn't say there, not just members of the board, but all the public and all those present. It doesn't define that. So those are things we have to get defined to make sure that the people know they go to the meeting, they have the right to speak. I've seen school board meetings, for instance, which is quite similar. People can't get the right to speak. A very serious issue in their community. They can't speak about it because the Act doesn't say that they can speak about it. The Act should say that people have the right to speak. There should be some rules on that to make sure that the meeting isn't taken over and the business of the meeting isn't done, but that the people have to have the right to speak. And it should be right in the Act. It shouldn't be in regulations later. It shouldn't be guessed. It shouldn't be maybe. So there's a lot of issues that have to be addressed in the bill. And we have to make sure that these things are done. I want to go back one more time. The occupational health and safety. That is, I'd like to see from the minister, hopefully, when he can provide us with some information, will give us a detailed breakdown on the budget within the department for the occupational health and safety part of the Department of Labor, to see exactly what the budget is, how many staff they have, and what the responsibilities are, how that's going to transfer into the Workers' Compensation Board. And if indeed, if it's going to be with the funding from the Department of Labor and continued funding in that spot, and if that's going to be in, if this is going to be in this, I'd like to see that included in the Act. So somewhere down the road, somebody can't decide, well, we're not going to fund the occupational health and safety regulations because we no longer need to. It's not in the Act. So that should be clearly laid out in the Act and indicate that that money is just not going to disappear to maybe pay for a shortfall in funding or some other thing that the province may need the money for at the time. At the same time, the safety issues of the workers and businesses will suffer. So I want to make sure that that money's there for the people to do and not on the backs of employers that have to pay for this thing. And the more they have to pay, the more the cost goes up. And the more the cost goes up to employers, the more the economy will suffer. It's just that simple. And so many times as legislators, we look at these things and say, oh, this is no problem. We'll raise another $50 million from this. It'll only be $100 per employee for every year. And then at the end of the time comes, that $100 means the difference between getting a contract from against some company in the U.S. or from New Brunswick or someplace else, and you lose the contract, and you have to lay people off. It's just that simple. It is that simple. But it doesn't seem to register with many individuals when they're doing these things. I think really we have to do more depth analysis on these things. Look at the big picture to make sure that we're not crippling industry, at the same time protecting workers, and at the same time giving the education prevention programs we really need in place to do these things. I can remember a few years ago when I ran my business, so I was building a new building, and this one building inspector insisted I put fireproof ceiling tile in my shop. Now, that had never been done before, and the building inspector was a little bit pushy in this regard, and I thought to myself, well, we've got no choice, we have to do this. And after a long time, we had to order the tiles in, they had to come in, they weren't available here in Nova Scotia, so they had to come in from outside the province. And we put them in place and never gave them another thought. That was not another thought until we had a fire in our building one evening, and those ceiling tile that the building inspector was so insistent upon saved the building from total destruction. And instead of going to probably $750,000 worth of damage. The damage is held to $100,000. I personally wrote a letter to the mayor of Dartmouth at the time and to the building inspector thanking them for doing an excellent job. That's the kind of thing we need to see from our occupational health and safety people. We have to see that, and we have to have them, excuse me, I've got a bad cold. We have to give them the latitude to do those things and to make sure they're not interfered with by anybody, that they can go do their job and need the adequate funding to do it. They need the proper training to do it, and they need the will of government to make sure that they're supporting them when they're doing their work. And they need the funding from the government, not from industry as a downloading operation could be. The cost and all these things only will work in a safe environment. If we have fewer accidents in the workplace, we have less costs for the Workers' Compensation Board. We have less costs for Nova Scotians, and everybody wins. And less cost and pain and suffering for Nova Scotians that are hungry. Order, please.
The honourable member for Preston has the floor.
Thank you, Mr. Speaker. So really, it's everybody works together. You can cut the accidents down. You'll never eliminate them, but you can cut them down. If we can cut the accidents down and eliminate some of the problems and some of the claims that people have to put forward because they're legitimately injured, the cost will go down. The cost in human suffering will go down. The financial cost will go down. Everybody wins. So we want to make sure when the Occupational Health and Safety Unit goes to the Workers' Compensation Board, if indeed that is the wish of government, which it appears it is, make sure they've got the funding to do it, then it's not tied into fees they get from employers from the workers' compensation fees that they pay. I feel the Department of Labor's role is to establish and clarify the responsibility of various parties under the Act and to intervene appropriately when these responsibilities are not carried out. Does the bill fundamentally change the relationship, or is it their cross-purpose with the Workers' Compensation Board? That's something I'd like the Minister to address when he makes his comments later. And the Department of Labor has to ensure that compliance with the Occupational Health and Safety Act is a primary directive, even when and if this goes to the Workers' Compensation Board. It's so important to have these things in place and have them working properly. I look forward to the comments of the Minister and of the government in this regard. I think that we've got a reasonably good bill here to work with. I think there has to be some major changes and some other things included in the Act, which we will discuss as we go forward, and we will be making recommendations for amendments to the bill, and we'll be working with the government to ensure that we get the best possible Act for the people of Nova Scotia, the employers, the employees, and indeed the people of Nova Scotia. Thank you very much.
Thank you. I recognize the Honourable Leader of the Official Opposition.
Thank you very much, Mr. Speaker. I'm pleased to join the debate this evening on Bill number 20, entitled An Act to Amend Chapter 10 of the Acts of 1994-95, the Workers' Compensation Act, and Chapter 7 of the Acts of 1996, the Occupational Health and Safety Act. Well, Mr. Speaker, the first thing that you have to ask yourself when you look at this piece of legislation is pretty simple. It's what is it doing here? Why is this piece of legislation before the House at this point in time? And the answer to that lies in the fact that it's here because the last time we addressed the Workers' Compensation Program and the Act, there was a decision by both the now government party and the now third party. There was a decision made that they were going to put through a bill that was not substantial enough to address the concerns that have existed about workers' compensation for some considerable period of time. That's the reality of it. And in fact, what the Liberal Party did and what the Progressive Conservative Party did in 1999 was ensure the passage of a piece of legislation which in fact guaranteed that the workers of this province would get fewer benefits, would get less under a workers' compensation scheme than otherwise. And then I see the former Minister of Labour saying that that's a foolish talk. Well, Mr. Speaker, it's not talk at all. It's fact. It is reality. And the Supreme Court of Canada has ruled on this. They have said very clearly that the attempt by the Liberals at the time to essentially punish workers. And let's remember that this is exactly what they did. They brought in legislation that tried to deny reality. They tried to deny that chronic pain existed. They said they're not going to bother to recognize these claims, and in fact they're going to ignore them. And it is not surprising that the Supreme Court would strike down the legislation, right, and rightfully so, because the reality for many individuals who are injured in workplace accidents is that they spend a large portion of their life dealing with the aftermath of an injury for which they were not responsible. I mean, they had the audacity and the temerity to get up from bed in the morning and go to work, and in return for trying to go to work and to work for their employers and try to earn a living for their family, they were injured. They were injured, and as a result of the legislation introduced by the Liberals and supported at that point in time by the Tories, they were not adequately compensated. Not adequately compensated at all. At all. And that has to do with certain salient facts that I believe the member for Cape Breton Centre set out in some detail, and it has to do with a kind of confusing mix of what the history of workers' compensation legislation in this province is all about. Because if you ask workers, I think many workers, in fact, I think if you talk to the Nova Scotia Federation of Labour, if you talk to those organizations that have an interest in protecting the rights of workers, if you talk to those people who go to work every day, they will tell you that the Workers' Compensation Board and the workers' compensation legislation is there to protect working people, and it's there to provide them with compensation for injuries that they receive as a result of engaging in their occupation, whatever it may happen to be. Well, Mr. Speaker, that's partly true, and it's partly true because that's where legislation has gotten us over the years, is a recognition that the compensation of workers for injuries they receive in the workplace is, of course, not only a good thing, but a necessary thing, the right thing, a moral thing to do for government to intervene on behalf of people who in many cases have little or no bargaining power, don't have the ability to stick up for themselves against what can be very wealthy and very large corporations. But that's not the root of workers' compensation legislation. The root of workers' compensation legislation, of course, was a design that was set up to protect the employers. And it was designed to prevent employees from having the right to sue employers if they were injured on the job, because, lo and behold, every now and then some sympathetic court, some court of equity would decide that an individual had received an injury for which they were entitled to significant damages, such that it damaged the economic prospects of that particular company. And of course, the companies didn't want that. I mean, they wanted to have some assurance that if they had a worker injured on their site, that there was going to be a compensation process whereby the worker would get compensated. And and then after they would get compensated, that would be paid for out of a fund of which the employer would contribute but not be totally responsible for. So it was kind of like a co-op for the employers, where they could pool the money, their premiums, and that out of that premium pool would be paid the cost of the injuries that were suffered by working people. The problem, of course, Mr. Speaker, like many things that have happened, sadly, in this province over the years, this particular program became a political football. And I'm not even talking about just the recent past, but over the years, if you look what happened, workers' compensation rates, of course, became an issue for employers. And I know there are people here today who are listening to this debate whose interests are around that issue. What is this going to cost, my particular employer? What is it going to cost businesses in order to be able to support the workers' compensation program? And I want to say that those are fair interests, and I have found, over the years that those people who are involved on behalf of the various industries treat this issue very seriously. And in fact, if you review the Dorsey report, you will find that there was a consensus that was reached. And that's not an easy thing to do when you look at the list of participants in Dorsey and realize the meeting of minds that had to take place and the negotiation that had to take place in order to be able to reach that consensus. I think you can say with some credibility that people obviously took their responsibility on that committee very seriously and worked very hard to close what must have been some fairly serious gaps in negotiation in order to be able to come forward with a report that has been, widely endorsed by many who see it as a way to address many of the concerns. And I got to that a long way, Mr. Speaker, I know, but what I wanted to say was that in the past, often the workers' compensation rates was a concern for industries who wanted to locate in Nova Scotia, so there would be some horse trading by the government around workers' compensation rates. And they would say, well, if I come in and I get a lower rate for workers' comp, then I can afford to come in and locate my business here. So even though the actuarial calculations with respect to that industry would say your XYZ rate ought to be charged, the government would arbitrarily decide that a lower rate was going to be charged. Well, of course, what's the result of that in the long run, Mr. Speaker? The result is that you build up a giant unfunded liability in the Workers' Compensation Board, and then you have to figure out how you're going to deal with it. And how the Liberals decided to deal with it was by restricting the benefits that were going to be paid out to working people. That was a straightforward decision that they made. So they decided that they would say, look, these injuries simply, we use the words a legal fiction. It is a fiction created by law that says that these accidents or that these injuries don't exist. It's very much like the legal fiction that the government is currently engaged in with its insurance bill, Mr. Speaker. There's a direct parallel because they want to arbitrarily cap injuries as if they don't exist at law. Or they don't exist at law, but as if they don't exist at all. Mr. Speaker, we can in this place create these fictions, but we must always remember that they are simply that. They are simply a fiction, and the reality is that many people will be made to pay a very severe price for those fictions. And in the case of the Workers' Compensation Board, it is injured workers, and in the case of the Insurance Act that has been introduced, it will be the victims of motor vehicle accidents. And And that's just the reality. But that is the trade-off that this government and the former Liberal government are prepared to engage in. They were prepared to engage in it with respect to the Workers' Compensation Act, and I think it's abundantly clear that they are willing to engage in it with respect to the Insurance Act. And no matter what they do to try and justify it, Mr. Speaker, in the end, it is unjustifiable. And in this particular case, the irony is that the Supreme Court of Canada has said that it is simply unjustifiable, and they have said in their decision, in a 9-0 decision, Mr. Speaker, that this was an unwarranted infringement on the rights of individuals, and they have given the government 6 months in order to make the changes that you see in this piece of legislation that we're about to talk about. Now, so that's what has gotten us to this point. That's what's gotten this piece of legislation here. Now, there's a bigger problem, of course, because what this legislation does is it deals with really two things. One is a 5% increase in the consumer price index with respect to the assessments or the calculations. And the other thing it does is with respect to the indexing of pensions. It increases from 50% of the CPI to 55%. Well, that's a good thing, you know. I agree it's a good thing, but it's not a big thing. It is almost the price that the government had to pay in order to bring this bill forward. They knew there had to be something else in here. And the second thing that is in this, of course, is the manner in which the government has decided that they're going to deal with the chronic pain, injuries that they tried to mystically and magically make disappear through illegal fiction. Well, I guess, Mr. Speaker, one of the big problems that we have here, and I think one of the big problems that people have just generally, is that much of what's going to happen with respect to chronic pain and the compensation of injured workers is not in the bill at all. Not in the bill. It's going to be in regulations. This process is going to be in regulations, and they are in regulations that we haven't seen. Now, this is a regular event for this government. It was a regular event for the Liberal government. They brought forward legislation. They put the meat of what they want to accomplish in regulations. Don't bring forward the regulations, so we never really know what the bill means. We never really know what it means for injured workers, and we won't know because that process is hidden. That process is going to take place behind closed doors. Well, I don't believe that a 5% increase in the indexing of pensions is a substantial price to pay for getting that legislation through the House of Assembly without comment and without us having an opportunity to point out how weak the legislation is.
The honourable member for Cape Breton West on the point of order.
Mr. Speaker, I understood the minister to stand in his place today and indicate quite clearly all three parties would be participating in the articulation of the regulations. Perhaps the leader of the opposition wasn't attuned to what the minister said. If I'm wrong, perhaps somebody in the House could correct me.
The honourable leader of the official opposition.
You know, Mr. Speaker, it always amuses me when the former Minister of Labour gets up and tries to defend these processes. You know, the reality for all of us is that the best way, in order to make sure everybody sees where the process is by putting it in the bill. Mr. Speaker, so that nobody has any doubt about the way in which this process is going to take place. And inviting us or inviting the Liberals to engage in the promulgation of the regulation is not a substitute for putting what you intend to do in the legislation. Because this, I mean, in the end, they're going to do what they want anyway. Well, once they have this act, Phil, you know, they can consult, and they often do this. They engage in the chicanery, the facade of consultation, and then go ahead, and then they'll go ahead and do what they want anyway. And they'll do it in regulations where there is no scrutiny, where it doesn't have to go to the Law Amendments Committee, where we never get a chance to comment on it in this House. Mr. Speaker, that is the point that I was making, and perhaps the former minister missed that, but he knows that that's the case, and in fact I have heard him on occasion, with respect to this government and with respect to regulations, make that very point. And there's all kinds of pieces of legislation that have come forward with regulations which were undescribed or vague in their intention. So we are unimpressed by the scope of this bill, Mr. Speaker. There were many other things that existed in the Dorsey report that could have been incorporated in this legislation. And here lies part of the problem, because I'm sure the government members will say, well, look, there's all kinds of good stuff in this bill. There's stuff that we'd like to see passed, that other workers would like to see passed, that injured workers would like to see passed. So why are you going to take the time to comment on it if you agree that much of what is in here is helpful? Well, Mr. Speaker, this may be the only piece of workers' compensation legislation that comes forward in this term of government. There's no obligation in the spring for the government to bring forward a further piece of legislation in order to strengthen the Workers' Compensation Act. They don't have to do it next year or the year after. In fact, they never have to bring their minds back to addressing the issue of workers' compensation if they choose not to. And it is the case that we could introduce a bill as an opposition party. We could introduce changes to the Workers' Compensation Act if we chose. But both us and the members of the third party, the Liberal Party, understand that if we do that, the only opportunity we have to call them is on opposition day, at which point the members opposite, whether they know anything about workers' compensation or care about it at all, can get up and run out the time on the bill that we bring forward, and they can do that every opposition day from here to kingdom come. And we will never get changes to the Workers' Compensation Act. So if we want to have if we really want to address the question of workers' compensation, we have to do it in the form of debate on this bill. Because every bill that comes forward to the House of Assembly is about two things. It's about what's in the bill, and it's about what's not in the bill. And oftentimes, sadly, with respect to workers' compensation, there's more that's not in the bill than is in the bill, Mr. Speaker. So we do intend to take some time to deal with this piece of legislation. Now, I have pointed out already to you, Mr. Speaker, and without going through a detailed repetition of what the Supreme Court of Canada has said with respect to this Act, it essentially sets aside those sections of the Act which discriminated against those who were suffering from injuries which were described as chronic pain. That's the nub of what this Act does, and you will see references in the bill, Mr. Speaker, that deal with the timing of of the calculation with respect to injuries, and you'll see that injuries are going to be calculated either from the date of coming into force of 15.1 of the Charter of Rights and Freedoms, or the date in which the worker was deemed to have been suffering from chronic pain, whichever is the latter. Because, of course, under the law, Mr. Speaker, that's the way that this becomes effective, is the effective date of 15.1, or at least that would be the argument that the government would make. There might well be an argument that says the Charter of Rights and Freedoms was really only the codification of rights that already existed. Because why else would we in a democracy recognize these rights if they didn't already exist? Did we create new rights under the Charter of Rights and Freedoms? And that's a debate that I know others here in other forms would love to take up, but I'm not going to get into that in this here today, Mr. Speaker. It's a bigger debate. But nonetheless, that is how this legislation is going to work. There are other things that happen in this bill that raise curious questions. You'll notice that education and prevention are taken out of the Department of Labor, but it's not really clear where they're going. They're not going to workers' compensation, so what's going to happen with respect to those aspects of the responsibilities of the Department of Labor? Who's going to do this? Is this something that's going to be farmed out to a private company, Mr. Speaker? What is going to happen on those issues? And that certainly is not clear. I think what you see from the government is the idea that this somehow encapsulates the spirit of the Dorsey report, and they're bringing forward pieces of a report that was, as I said, a unanimous report. And I suppose that in some limited sense that is true, but it does not bring forward the kind of major pieces of the Dorsey report. And I believe we've heard before the opinion of the government and by extension, I suppose, the board, which is that it's simply not doable at this time. And it has never been clear to me exactly why they say that is the case. I mean, I do understand the excuses that have been given, but I've never really understood, on what basis they were selling that. So there's a lot in this bill and a lot not in this bill. I know that just before I certainly heard other members speak. I heard the critic for the Liberal Party talk about how much is involved in working on behalf of those who suffer injuries in the workplace in your constituency office. And this is something that if the new members of the House of Assembly have not dealt with yet, I can assure you that if you haven't dealt with it by this time, you will very, very shortly, because it would be amazing to me that you could escape not working on behalf of one of your constituencies with respect to a workers' compensation board case, because they seem to be absolutely everywhere. Every time you turn around, there's somebody. I certainly had and have written a letter on behalf of an individual in my constituency just the other day before the Supreme Court of Canada decision came down on the very issue of a chronic pain injury. And not surprisingly, the day after this decision came down, I received another call from him because obviously this is going to affect his life. So we are all out there I know, and there are many, different kinds of issues that arise out of the Workers' Compensation Act. And one I don't believe has changed, Mr. Speaker, is that whole question around, a person who is at work in a motor vehicle, and they get into a motor vehicle accident. Under the existing legislation, the board has the right to seize that claim and put it forward on their behalf. And in fact, the worker loses all of their rights to compensation. Now, this may become less of a problem after the Tories and the Liberals are finished putting forward the Insurance Act, because it won't be worth anything anyway, Mr. Speaker. So I suppose in some senses they're dealing with that problem, but just not in a very, very prudent not in a very prudent way. So I think I've had an opportunity to begin the discussion on this act, Mr. Speaker, and with that, I am going to move the adjournment of the debate.
Motion to adjourn debate. Is it agreed? Request for a recorded vote. Recorded vote has been called for. We'll ring the bells to the satisfaction of the whips. Order, please. The whip satisfied? Yes. Recorded vote has been called on the German debate. The clerks will call the roll. Those in favor will say aye. Contrary-minded will say nay.
Mr. Clark. Nay. Mr. Morse.
No.
Mr. Rodney McDonald. Absent. Mr. Russell.
No.
Mr. Ham.
No.
Mr. Baker.
No.
Mr. Muir.
No.
Mr. Christie.
No.
Mr. Fage.
No.
Mr. McIsaac.
No.
Ms. Bolivar Gibson.
No.
Mr. D'Entremont.
No.
Mr. Hurlbert.
No.
Mr. Barnett.
No.
Mr. Morash.
No.
Mr. Taylor.
Absent.
Mr. DeWolf.
No.
Mr. Dux.
No.
Mr. Chisholm.
No.
Mr. Langell.
No.
Mr. Hines.
No.
Mr. O'Donnell.
No.
Mr. Chataway.
No.
Mr. Parent.
No.
Ms. Massey.
Yes.
Mr. McDonnell.
Yes.
Mr. Corbett.
Yes.
Ms. Maureen McDonald. Absent. Mr. Dexter.
Yes.
Mr. Duval.
Yes.
Mr. Manny McDonald.
Yes.
Mr. Graham.
Yes.
Mr. McKinnon.
Yes.
Ms. Whalen.
Yes.
Mr. Gaudette. Absent. Mr. Glavine.
Yes.
Mr. Caldwell.
Yes.
Mr. H. Dave Wilson.
Yes.
Mr. Sampson.
We.
Mr. Steele.
Yes.
Ms. Moore.
Yes.
Mr. Parker.
Yes.
Ms. Raymond.
Yes.
Mr. Epstein.
Aye.
Mr. Pye.
Yes.
Mr. Goss.
Yes.
Mr. David Allen Wilson.
Yes.
Mr. Estabrook.
Aye.
Mr. Sampson.
Yes.
Mr. Theriot.
Yes.
Mr. McNeil. Absent.
Those in support of the motion, 24. Those opposed, 22.
Motion is carried. Debate is adjourned on bill number 20. The Honorable Government House Leader.
Mr. Speaker, would you please call public bills for third reading?
Public bills for third reading.
Speaker, would you please call Bill number 11, the Collection Agencies Act?
Bill number 11, the Collections Agency Act. The Honorable Minister of Service, Nova Scotia, and Municipal Relations.
Mr. Speaker, I'm pleased to move Bill number 11, the Collection Agencies Act. Third reading.
Motion is for third reading of bill number 11. Is the House ready for the question? All those in favor say aye. Contrary-minded, nay. Motion is carried.
Bill 11, entitled An Act to Amend Chapter 77 of the Revised Statutes 1989, the Collection Agencies Act, and Chapter 91 of the Revised Statutes 1989, the Consumer Creditors Conduct Act.
Order the bill do pass. Order the title be as read by the clerk. Order the bill be engrossed. The Honorable Government House Leader.
Speaker, I move the House to now rise to meet again on the morrow at the hour of... Whoops, Mr. Speaker, would you please revert... could I have the concurrence of the House to revert to the order of business presenting reports of committees?
Is it agreed? Reports of committees. The Honorable Minister of Justice.
Thank you, Mr. Speaker. Mr. Speaker, as Chairman of the Committee on Law Amendments, I am directed to report that the committee has met and considered the following bill. Bill number 6, an act to amend Chapter 377 of the Revised Statutes 1989, the Public Service Superannuation Act. The committee recommends this bill to the favorable consideration of the House without amendment.
Order this bill be referred to the Committee on the Whole House on Bills. The Honourable Government House Leader.
Mr. Speaker, I move the House to now rise to meet again on the morrow at 11 a.m. The House will sit until 5 p.m. And the order of business following the daily routine and question period will be Committee of the Whole House on Bills, and then subject to the concurrence of the House and a reporting of bills back from the Law Amendments Committee, Mr. Speaker, will go into Committee of the Whole House on Bills.
Order, please. Order, please. Order, please. The Honourable Government House Leader.
Was questioning the hours for tomorrow and the fact that the presentations of the Order of Nova Scotia, the 11 a.m. to 5 p.m. we agreed to some time ago to accommodate that particular event. So, Mr. Speaker, I'd move that the House to now rise, and as I say, tomorrow we will have the results of Bill number 1 back from Law Amendments, hopefully, and that will be our primary business on the morrow.
Motion. The Honourable Member Cape Breton South.
A late show tomorrow or not? No? Okay. All right.
Agreed. The motion is the House adjourned to 11 a.m. Is it agreed? All those in favor say aye. Contrary minded nay. Motion is carried. We're adjourned to 11 a.m.